but we're kind of talking about the first steps that need to be taken into account when you are planning on starting off a webinar. And I see something popping up in the chat. Just a reminder. Oh, I'll be providing a PDF circulated after the fact. Thank you, Katie. Of course, I encourage you to take notes nonetheless. But okay, so not-for-profits. Before we start, what you need to know. So to start off, the lawyer in me can't begin without giving this wonderful disclaimer: is that obviously this presentation is for free informational purposes only and does not constitute legal advice to your specific situation. And obviously, my bosses want me to let you know that does not create a retainer between you and Doak Shirreff lawyers. Any views or opinions expressed are my own. Consider this to be the same as if you are reading a blog online or a letter to the editor from a lawyer. And it's important to keep in mind that law changes and evolves over time. The information that I'm giving on this date may not be applicable to your circumstances in the future. So if you are watching this on a recorded session or referring to your notes sometime in the future, obviously we encourage you to seek legal advice with respect to your current circumstances and specific facts. Okay, so with that wonderful disclaimer out of the way, let's talk about not-for-profits and startups. So why does this matter? Why does this presentation matter? Well, that slide's from the last presentation I gave. I used the new, I used the same formatting, so I apologize for that. This is supposed to be the first slide. What is a not-for-profit? What are we talking about here? So a not-for-profit organization is also known as a society. And I'm going to be using the word society much more often throughout this presentation rather than the not-for-profit. They are interchangeable terms. Basically, a not-for-profit organization or a society is an incorporated entity that is not driven by profit. That's probably the most basic way that I can put it. But let's back up a little bit because I'm using a word here, incorporated, that I don't want to charge ahead assuming that everybody understands what the significance of incorporation is. So a not-for-profit organization or society is an incorporated entity. So what is an incorporated entity? Well, an incorporated entity is a corporation. Incorporation, it's in the name. Corporations themselves are creations of law that are made by fulfilling certain formal steps or requirements that are set out by statutes for creating a corporation. The result of an incorporation is this separate, distinct legal entity, or quite honestly, the word that we use in law is you're creating a legal person. It's a person in the eyes of the law, just as I am or just as you are. It might not be a human, but it is a person. An incorporated entity or a corporation or a society, it can sue, it can be sued, it can enter into contracts, it can open bank accounts, it can hold property in its own name, it can open property in its own name. Basically, as far as the law is concerned, it is a person just like you and me in the way that it can operate in this real world that we have here. But of course, it doesn't necessarily have a body, but it does have a mind. And the mind of this new person created by law is its directors. And when there's more than one, it's a board of directors. And I'm sure these are all terms that you've heard before and are likely familiar with, but it's an analogy that I sometimes use to explain this to people who it's the first time they're learning about this concept of corporations. It's similar to in Wizard of Oz, where Oz, the great and powerful, big floating head, has a name. Everyone's aware of Oz, the great and powerful, and Oz, the great and powerful, sets laws in the land. But of course, there's a person kind of pulling the strings behind it. It's a little person behind the curtain, but who's the operating mind of Oz. But there's this distinction between who that floating head is and the person pulling the string. Sort of a bit of an illustration for understanding incorporated entities. I saw a question pop up in the question and answer. I'll just knock that off right now. No, a social enterprise is not considered a not-profit in the way that we're addressing it in this presentation. So here's a quote that gives it a little bit more legal oomph. I didn't come up with this quote, but it's a corporation is a artificial being, invisible, intangible, and existing only in the contemplation of law. It's a separate legal entity from its shareholders, its liabilities being its own and generally not those of its shareholders. Corporations which exist for engaging in businesses and producing profits are often known as companies, so sort of different between a society and a company. They're both incorporated entities, but there's a difference between the two. And companies, of course, who are mind to profit, are registered under the BC Business Corporations Act. So now we've got an idea of what incorporated entities are, what the difference is between the ones that are for profit and the ones that are not for profit. So let's bring it back to the topic of today's presentation, not-for-profits. So while many not-for-profit organizations can be unincorporated, those that are incorporated either under the British Columbia Societies Act, which is why I use the word societies. And there, I'll note that just a couple of years ago, 3 years ago, the British Columbia Societies Act came into force. It was which replaced the former Society Act. And there's also societies can be, or not-for-profits can be incorporated via the federal Canada Not-for-Profit Corporations Act. I'm going to be referring more to the BC Societies Act for the sake of this presentation, because obviously I need to draw some lines somewhere. So we're just dealing with the BC realm right now. So it's also worth noting, for those of you who were present at the last presentation that we gave, which was all about charitable status. Charitable status is something that societies can obtain, which is pursuant to the Income Tax Act, basically being able to produce tax receipts and the like. We're not touching on that as much or at all really in this presentation, aside from this slide. There was a whole presentation dedicated to it the last time around. But I do want to just throw out here for the sake of clarity that just because a society is created does not mean it's a charity. Not all societies are charities. It's a very distinct and specific set of standards that need to be met for a society to obtain charitable status, which is the subject of the last presentation. Okay, moving right along. Okay, so as mentioned, not all not-for-profit sort of organizations are actually incorporated entities. So let's quickly chat about the difference between the incorporated organizations and unincorporated organizations, because obviously there can be not-for-profit initiatives, which are simply people coming together and trying to obtain a certain goal. Again, not really what we're talking about now, but I'm just trying to create some distinctions here. So there is a distinction between incorporated organizations and unincorporated organizations. As we just went over, incorporated organizations create a legal person. Creates what we call, the term we use in law is we call it a corporate veil, where basically those running the operation behind the scenes are protected by that curtain. And so they can enter into contracts, but the people who are behind the curtain aren't the ones held liable for those contracts. Instead, it's this new legal person. It's Coca-Cola Inc., not the CEO of Coca-Cola. Unincorporated entities, however, or maybe I shouldn't even say entities, I'll just say organizations that are unincorporated, are more informal. They don't have a distinctive legal status, and liability rests directly on those who are acting under that umbrella, regardless of their title. So that can be principals, members, volunteers. If it's not an incorporated entity, people are just acting under this sort of title, but they carry their own liability. Whereas the incorporated entities create this corporate veil, a shield, so to speak, between people actually doing the actions and the corporation that sort of carries a lot of the liability. It obviously doesn't stop all liabilities. People acting negligently will still carry liability for their personal negligent acts. However, if the incorporated entity, the legal person, is found to be liable, those who guided that corporation to make to take certain steps that resulted in this liability, they may not carry that liability themselves, barring certain exceptions. But again, that's a whole other discussion. Obviously, we wouldn't have our current legal system and lawsuits as we know them if just creating a corporation immediately stopped liability. So there's a lot more to it, but just be aware that that's one of the main reasons why people will incorporate a society or a business. It's basically to create that separate legal person who can take the burden, take the risk. Okay. So as I just mentioned, the most common reason for incorporation is to take advantage of that limited liability, which is the term we use. So why does this matter in a not-for-profit circumstance? Well, because many not-for-profits put on activities in which individual members could incur liabilities. Think of any kind of fun run events or charities where you're serving food to the public, you name it. It's not hard to imagine situations where activities being put on by a not-for-profit, despite the best intentions, can still result in risk that could harm others and result in liability for the people who are putting on that risk or putting on that activity. So incorporating it kind of adds that protection. There we go. And I guess I got ahead of myself earlier. It is worth noting that even if you are working under the umbrella of an incorporated entity, creating that corporate veil, which limits liability, volunteers, directors, members of a society can still carry or will still carry personal liability when they fail to meet a duty of care or a standard that's expected of them in the way that they carry out the duties. The organization whose umbrella they're under can also carry the liability flowing up. For those of you who were present at my presentation, which was focused entirely on volunteers, this is something we went over, which is called vicarious liability. And it's just worth noting that, again, as I go into all this detail about why would you want to explore the idea of incorporating an entity, it's to limit liability. That's the first and foremost goal of it. So that this new entity can carry on your tasks or your activities, but be aware that it obviously doesn't limit everything, and liability of your volunteers or the people working under that umbrella can still flow up, and the incorporated entity can now carry that liability through vicarious liability. And here's some details here. I'll maybe go through this slide very quickly. So organizations can be held liable for the actions of the volunteer if the volunteer is under the control or direction of the organization and acting within the scope of their responsibilities. Additionally, if a volunteer appears to have authority to act on behalf of the organization or this incorporated entity, the other party believed they represented the organization, then the vicarious liability can still be found. This we went into detail during the volunteer presentation, so I won't delve too much into this slide. Again, also with respect to liability not completely being cut off with respect to incorporated entities, in an incorporated organization, it's obviously going to be overseen by a director or board of directors, and directors themselves also carry an inherent, what we call fiduciary duty, which is a duty to act in good faith and in the best interests of this new legal person they've created. Basically, as we said, it is creating a legal person, but pulling the strings of this puppet are the directors, and they have responsibilities not only act in good faith and in the best interests of this new person that's been birthed by law, but it also carries with it certain liabilities for the decisions that they make via this new legal person. And it's worth noting as well that directors who have special skills or expertise are held to a higher standard because obviously what they are bringing to the table in running this not-for-profit. They have a higher duty to practice the standard of care equal to their professional liabilities. So, for example, if you have a chartered accountant who's on a board reviewing financial statements, well, they're going to be held to a higher standard of care than somebody who doesn't have that same professional training. The law sort of takes people where they're at in that sense, which of course means holding people to the standard expected of them, given who they are and their background. Fiduciary duty, if that's not a term you're familiar with, basically it includes the duty to avoid conflicts of interest, not to engage in criminal activities, and a responsibility to maintain the organization as a legal entity, which means keeping up to date with your records and filings for that organization. Okay. And it's worth noting that the British Columbia Societies Act sets out the roles and responsibilities of nonprofit organizations and board of directors. Okay, so the reason I started with all of that was to give sort of an overview of what a incorporated society or not-for-profit looks like. It's this new legal person created so that it can carry this weight of responsibility, but the people who are guiding it, steering it, and pulling the strings behind it do have certain responsibilities that they have to live up to as well. So once we kind of know that's the end goal, that's what we're hoping to create, let's get to the name of this presentation, I guess, which is Before You Start. Okay, so obviously the first step, this isn't a legal question, more of a practical question, but what is your goal? Why is it that you want to create this not-for-profit and maybe incorporate it to be a society? What's your mission statement? This is critical because every decision that's made by you and the rest of the board of directors in steering this new ship should be guided by the goals of what this creation was created to be, what its point was essentially. So just a practical piece of advice is it makes sense to have a mission statement, have something that's clear, concise, that you can always come back to and recognize this is our goal and this is what we're going towards. Now, that's a little bit different from understanding what the purpose of the society is going to be. The goal obviously is just more of a practical sense, but when I'm talking about purposes, that brings it back down to how the law is actually approaching incorporations of societies. So an incorporated society may be formed for any lawful purpose, but the Act, the Societies Act, actually has a list of examples for what it says societies can be created for. Agricultural, artistic, benevolent, charitable, educational, environmental, patriotic, philanthropic, political, professional, recreational, religious, scientific, social, or sporting. Pretty broad. Chances are whatever thought you had in mind is probably going to fall under one of those categories, and that's why it's why they're enumerated in the Societies Act. And again, I reiterate the point that charitable status requires certain standards and purposes to be met that are prescribed by the Income Tax Act. Different conversation than what we're having now. A society is not necessarily a charity, and it's a separate thing to keep in mind. So here's the actual clause in the Act. It's Section 2 of the Societies Act. You can see right there that list that I just named. Now it's worth noting on Clause 2 or Subclause 2 and Subclause 3 right there, where a society must not have as any one of its purposes carrying on of a business for profit or gain. But carrying on a business to advance the purpose of the society is not prohibited. So again, that kind of reflects back to that distinction that we touched on earlier between the difference between a society, an incorporated not-for-profit, and a company, which is incorporated for the purposes of making profit. So the Societies Act right away is very clear of the difference, and you cannot create a society that has a purpose of basically making profit. And it's worth noting that when the society sets out what its purposes are, the registrar, who the application for incorporating a society is registered with, they have the authority to respond and basically say, no, the purposes that you're setting it out for aren't lawful or aren't appropriate under the Act. So they have that authority to say yay or nay. Okay. So you have your mission statement, you have your idea of what your purposes are for the society. It runs under probably one of these categories right here, and it's on unlawful purpose, and it's not to make a profit. So how do you incorporate? Well, first things first of this process is name approval. You probably have a name that you want to name the society. There's lots of societies out there, and it's not impossible for the same clever name that you came up with, whatever puns or witty idioms it might be referring to, it's possible that that name is already taken. So start off with seeking name approval and reservation. So that's done by submitting what we call a name request form. So step number one, make sure you can actually call this society what you want to call it. Next, what kind of society is it? So the Societies Act actually now provides for two different kinds of societies. I didn't really touch on it. You may recall from an earlier slide where I mentioned the Societies Act is relatively new, came into force just a few years ago. It replaced what we call the Society Act. And one of the changes that came around with the Societies Act, the new one, is it created a new kind of society that we call a member-funded society. Basically, it's a society where members pay in, and it's entirely created for their own benefit. They're paying into something that they get the benefit from, basically exclusively. I think a good example of what this can include would be yacht clubs. A yacht club, the Kelowna Yacht Club here, would be a member-funded society. It's a not-for-profit organization. How its function is to basically be there as a nice little resource for its members. Excuse me, I'm just going to take a drink of water. Okay. So, who is doing this incorporation procedure? Well, one person or more people can kind of carry out the incorporation procedure. Obviously, me being a lawyer, I recommend that you reach out to a law firm to assist, although it's not necessary that a law firm assist. We're just more familiar with the process, obviously, so it keeps it a little more streamlined. And it's worth noting, because we explained before, that an incorporated entity is a legal person. Technically speaking, a corporation could push through the incorporation process. Again, kind of giving you an idea of this new legal person that's created. They can open up bank accounts. They can create other societies. The BC societies must have, it's worth noting that societies that are created in BC, pursuant to the BC Societies Act, must have at least 3 directors. 3. So again, what do you need to know before you start? Well, there'll be you, obviously, but you got to have at least 2 other people who are willing to be those first directors, helping be this mind of the new society. And at least one of them must reside in British Columbia. And there's different standards for member-funded societies, but I'm not going to get into that because member-funded societies aren't really the focus of this presentation. So, directors. So who are the directors of the society going to be? And as mentioned before, because of the standard that directors are held to, these fiduciary duties and certain responsibilities for them to carry out, to maintain annual filings of the society, review financial statements, be held to a certain standard of keeping that society lawful. Obviously, you want to make sure that the people who are being chosen as directors have knowledge and skills that they're bringing to the table. It's one thing for people to think, well, I'll just get some people who also believe in this purpose and want to help me create this society to achieve our goal. But it's important just to remember the standard that directors are held to, and you want to make sure that you're choosing the right people for the right roles. So this is something that you don't want to be turning into an afterthought, but rather something to consider on the front end, because you do need to have at least those first 3 directors before you can even incorporate the society. And again, as I mentioned right here, directors and officers of society are subject to duties and liabilities, so be aware of that. And it's also important that those people who are being chosen for the, or not chosen, but who are electing themselves to be directors and are volunteering to be directors with you, it's important that they are aware that being a director, being on a board of directors is not just a cushy job that gives you a nice title and maybe beefs up the resume a little bit, but rather it does carry, like we said, duties, responsibilities, and it also carries personal liability with certain obligations. One example is it can carry some tax liabilities if there's a failure to remit the appropriate taxes through the society. Again, you're the operating mind of this new legal person. But also something is that if the society has employees who are obviously entitled to wages, directors under law in British Columbia can be held personally liable for a certain for a certain period of time of unpaid wages for employees. So if a company the legal person, the company that's hired these employees, goes bankrupt, let's say, and can't pay the last paycheck, let's say, of these employees, the directors can be found personally liable for those unpaid wages. Law in British Columbia, law in Canada generally, but British Columbia specifically, is very employee friendly. There's a power imbalance, and if employees providing work and they're not being paid, even if it's for a not-for-profit society, the law will look to anybody they can to help support these employees. And in this specific example, for unpaid wages, the finger gets pointed at directors. Okay, so there's also certain qualifications when choosing your directors. So a director must be qualified under the Societies Act and the bylaws of the society. So the Societies Act requires that they must be at least 18 years of age, subject to some exceptions. The certain conditions for having directors of a society who are under 18 years old are set out by the Societies Act regulations. The Societies Act, or the director obviously must be capable of managing their own affairs. With respect to capacity, obviously. They cannot be going bankrupt, and they cannot be convicted of fraud or a corporate offense within the last 5 years. And of course, there can be any other requirements noted in the society's bylaws. So we'll get to bylaws in a little bit, but basically the neat thing about bylaws is that they can be, as long as they're not contrary to what the Societies Act sets out, bylaws can basically be whatever you choose them to be. And you can set standards that help you structure your society the way you're looking for it, your not-for-profit, how it's operating. But we'll get to bylaws in a little bit. But the point is the bylaws can dictate certain specifics for who is on the board of directors. Maybe a good example might be, I don't know, let's say MAD, Mothers Against Drunk Driving, might have a requirement that its directors cannot have may not have at any time in their life have had a drunk driving criminal offense or something like that. Okay, so going back to how you incorporate. So maybe taking it back to where we were at. So we have to have an idea of what our purposes are. Have that lined up. You want to make sure that you can get the name. You want to know what kind of society you're going to be. You're going to know who's going to be running it. All of these types of things are basically what you want to have in the back of your mind or written down somewhere, so that you understand what's going to be the skeleton of this organization, who's going to be the mind, what's going to be helping run it. Then how to incorporate what you actually need to submit is the Constitution. So the Constitution of the society is a document that you file with with BC Registry Services, which is the society's name and its purposes. This is a short document. It basically outlines what its name is going to be, which you'll already have had reserved, and you'll know it's clear to register. And then you'll have the purposes, which outline the general purposes, specific purposes of this organization. And if your society is going to be one of these member-funded societies, then one of the terms that gets included in the short Constitution. Constitution is not the bylaws; it's not a lengthy document, often just a one-pager. But if you're a member-funded society, it has to include this particular term, which is that, quote, this society is a member-funded society. It is funded primarily by its members to carry out activities for the benefit of its members. On its liquidation or dissolution, the society may distribute its money and other property to its members. All right, so bylaws. So the Constitution is one thing, name and purposes. Bylaws are separate. Again, as I just referred to, it basically outlines how this organization is going to govern itself, and how those within it are going to be governed. So a society must have bylaws that contain, this is from the Societies Act, Section 11, a society must have bylaws that contain provisions respecting the internal affairs of society, including, which means these must be in there, provisions respecting the following. Number one, membership of the society. Who can be a member of this society? So what the admission requirements are going to be, if there's different classes of members, what that means, and if a member can be in good standing, bad standing, what that means. And usually this refers to things such as if voting rights are going to be an issue with respect in the society, for the society. For directors. So how are directors going to be elected or appointed? How long is their term going to be? That needs to be included as well. And generally speaking, it's every year is the term. So if it's not going to be the standard, which is the close of the next annual general meeting, then that needs to be dictated by bylaws. What meetings are going to look like. So as mentioned, one of the responsibilities of the directors is to make sure that the society is properly run, which includes maintaining annual filings, annual general meetings, financial statements. And so because there are these requirements, you obviously want to have an idea of, okay, well, when we do hold these meetings, which are mandatory, how are we going to hold them? So how are we going to hold our AGM? How many people need to be in attendance? If we're going to be voting on something, how many people need to be present to vote on something? And you can see just again, section 11 term right here, it gives some guidance of these things need to be covered by the bylaws. And similarly, societies can have all sorts of purposes. I won't go back and rapid read that list again, but like I said, is everything from well, I won't go through the list again, all sorts of reasons. But based on depending on the reason or the purpose for your society, you may choose to have restrictions with respect to how the society carries on its activities or what kind of activities the society can carry on, or the powers that the society may exercise with respect to those activities. So it's important to remember this is just a very brief section 11 overview of your bylaws must have all of these things addressed. And it's worth noting that societies are responsible for ensuring that their bylaws comply with the Societies Act. Now, because drafting bylaws and laws in the name isn't a simple thing necessarily, so naturally I encourage people to reach out to a lawyer. It's in our name as well. Drafting bylaws is our bread and butter. We understand where those boundaries are and what will make an enforceable bylaw, or what bylaws might result in more trouble than they're worth. And so obviously, please feel free to reach out to a lawyer before starting to draft your bylaws. Now, let's say drafting bylaws is not something that you're interested in whatsoever. It is also possible to use the standard bylaws, which are available online through BC government websites. I don't have the URL up here, but there are standard bylaws that can be registered. What's important to keep in mind, though, with respect to the standard bylaws, is that there are certain requirements that there are certain things within the standard bylaws that have been provided by the BC government that may not be appropriate for your not-for-profit. The one that comes to mind immediately for me is proxy voting. So the standard bylaws that if you were to file the standard bylaws in your incorporation package, those bylaws are going to include a restriction on voting by proxy, because that's just how they're drafted. Now, if voting by proxy, which means being able to submit your vote if you're not present at the actual meeting to raise your hand, if the nature of your society is that you need there to be proxy votes, maybe because of where the membership is across the country or out of town, whatever the case might be, then the standard bylaws are not going to be appropriate for you and aren't what you want to file in the first instance. I'll get to that in a sec. I lost my train of thought. Sorry, that's the problem when you have the question and answer tab popping up, and you get easily distractible like me. As mentioning, so proxy votes is the one that comes to mind immediately, because I know the standard bylaws don't allow proxy. If your charity or if your society requires proxy voting, it may not be appropriate. Oh, thank you. The model bylaws are now in the chat. I appreciate that, Dorothy. There's the link for where they are available. So it's worth going through, understanding how it applies to your organization, and being aware that there might be things that are in the model bylaws, standard bylaws, that don't meet your requirements. It's worth chatting with a lawyer to recognize how those can be changed, getting them changed and drafted to hopefully what your final form of bylaws are going to be in the first instance. rather than having to file the model bylaws and then go through the whole process of amending your bylaws, which requires directors' resolutions, opportunities to vote by membership and the like. So it's basically do it once, do it right is, I guess, probably the best way that that I can recommend for how to approach your bylaws in the first instance. Okay, and so basically, that is sort of the end of the presentation with respect to the incorporation package. I know I sort of went a mile a minute with respect to the beginning of it, because in essence, what you need to know going into commencing or starting up a not-for-profit or a society is being aware of A, the process, B, the responsibilities that you carry as the person going through this process, and having an understanding of how these moving pieces all come into play. I recognize that this was a little bit faster than what some of the previous presentations were, and I think part of that is obviously just giving it, sort of speaking to my computer screen without getting too much feedback. So this might be a good time to open it up to question and answers. If Dorothy wants to help facilitate that.
I will.
Fantastic. It's worth, I'll note there's one anonymous question right there. What are the fees associated with starting up a society or incorporating a society? The short answer is that's going to differ depending on law firms. Generally speaking, law firms will carry that based on a tariff cost. I think it can sometimes come to, I think it's safe to budget or be prepared for under $2,000 but above $1,000 for a law firm assisting. If it was going to require hefty rewriting of the bylaws, for example, then it would be more. For those of you who haven't had the pleasure of working with lawyers in the past, the way that we operate is generally speaking off of hourly rates. So and every lawyer will have a differing hourly rate based on their years of experience or specialization. And so obviously if a lawyer spends 1 hour drafting those bylaws, well, it's going to cost a certain amount. If they spend half an hour, well, it's going to cost half of that, right? So when it comes to the process involved with drafting customized bylaws, well, it's going to depend on how complicated it's going to be, how much it differs from the standard bylaws, let's say. But the process for assisting with basically all of those steps as I've outlined them today, it's usually a tariff cost. I think Doak Shirreff's is roughly around $1,500 front to finish, which also includes leaving Doak or placing Doak Shirreff as your registered records office, which accommodates us reminding you and assisting you with annual filings and the administrative side of things in the back end. All right. Great question. I see them.
Oh, good. We can
look at that. Okay. I'll start with the messes. What are the top legal risks you see in operating a society? I think, to be honest, the best answer I can give there is that societies are a unique beast because they're often operated by people like you who are in this audience, who have the best intentions. They are, their heart's in the right place. They're volunteers in many cases, balancing their already busy lives to also push forward the goals, the purposes of this society. But because they're busy and because this is something that they're doing in addition to the rest of their life, they might not be as knowledgeable as they ought to be with respect to the duties and requirements and standards they have to meet as directors or volunteers within the society. As you may know, for those of you who attended, we dedicated an entire night to volunteers and the law. And I know I joked a few times throughout that presentation that it sounded very doom and gloom. And I could see people writing notes the whole time, these panicked faces as they realized that all of their well-intentioned, good-hearted volunteers are actually exposing their organization to a lot of liability, whether it's a volunteer driving a van of underprivileged teens up to Big White for a snowboarding trip. Oh boy, the liabilities that are carried with that great effort, that wonderful purpose for whatever that society, hypothetical society, might be. Boy, is there a lot of risk that's being carried because they didn't take into account the need for waivers and liabilities and training and the standard of the driver that would need to be met for carrying on a role like that. Because again, the goal, the mindset that all these volunteers and directors and people like you are at, it's how can we achieve this goal and how can we just carry it out without thinking of all the horrible things that could happen. I once heard someone refer to lawyers as being pessimistic perfectionists, which I thought was a wonderful way of putting our profession, because we're dedicated to focusing, or paid paranoid is another way I've heard it, because we constantly are focused on looking at how the world has gone wrong, can go wrong, and continues to go wrong, and how can we help our clients put their pieces into place to make sure they stay out of trouble. Again, the problem is with operating society is, especially a not-for-profit, they don't necessarily have deep coffers. So as a result, they avoid going to lawyers in the first instance because lawyers cost money. And then they get themselves into situations where, well, now they're serving food to people in a soup kitchen, but did they get the proper licenses and training that they need for serving food? I mean, these are all just examples off the top of my head, but they kind of illustrate what I hope is the short answer for your question, where what are the top legal risks you see? It's people charging ahead with the purposes of this organization and not recognizing how many risks there are with their organization. Thank you, Inessa. I'm sure Dorothy will forward my contact information to people after the fact, and I'd be happy to reach out to you later. Can I get a PDF of the Societies Act, please? So the Societies Act is actually available online. If you do a Google search for Societies Act BC, it'll probably be the first one that starts up on the website BC Laws.
I also just posted a link to it as
Oh,
well.
there you go. I see it. Perfect. Fantastic. Yeah. So the Societies Act is right there. And as I mentioned, keep in mind that in legislation, we often have what we call the Act, which is it's the Act. There's also the regulations, which are almost like a schedule or addendum to the Act, and they help clarify some things that are in the Act. The regulations are easier to amend than formal legislation. So an example of where those two parts come into play is obviously the Act says no directors under 18, subject to what the regulations say. And then you can look to the Societies Act regulations, which give you some guidance about how you can have those high schoolers on your board of directors if that's necessary.
Sorry, Johnathan, can I just also answer Darlene's question about the charitable status?
Yes,
that
absolutely.
recession we did it through Zoom as well, and we do actually have it on our website, but I'll provide a link. I'll look for the link because it's on our YouTube channel, and so people can check that recording out as well, and then if they'd like, they can get the PDFs from me from it as well. Okay.
Perfect. Can an unincorporated not-profit receive donations? Yes, anyone can receive donations. The difference is how that donation gets treated. Unincorporated not-for-profits will not be able to receive donations that are no tax receipts, for example, for those types of donations. Unincorporated not-profits, I mean, basically it's a gift, someone providing it to the people who are operating this endeavor. However, let's say that person who provided a donation was unhappy with how their donation got used by the unincorporated couple, let's say, who are pushing forth on their endeavor. Well, then you've got people versus people where, knock on wood, it never happens, but if a lawsuit were to arise, I gave you that gift, that donation, because I thought you were going to use it a certain way, and you used it this way. You used it for your own personal means, as far as I'm concerned. well, then you've got this kind of personal dilemma, which, again, I bring that up just because it's an example of where an incorporated entity might be able to avoid that personal liability in this situation. Yeah, donation is a tricky word because it's loaded, because usually when you think donations, you'll think of being able to get tax receipts back. But if you're just thinking, can you accept a gift of money? Well, of course you can. But just be aware of the risks that come with taking money from anybody. Yeah, I hope that answered your question.
Okay. So I'll just for people, they may not be aware how they can raise a hand, but if you go to the participant tab, and then you should see your name, and it'll allow you to put up a hand if any, somebody's just figured that out. Or, so we'll go there, and then I can unmute you and you can ask a question. I lost the person. There. Okay, Ethan.
I see Mike's got a question too about societies required to publicly disclose their financial statements. So the financial statements will be reviewed in the AGM, which would obviously be available to members to attend. And financial statements are often also circulated as well. I'm going to say, generally, yes, they are available for members to seek out and request and to review. But our society is required to sort of publicly to the public at large, if that's what you're asking. And the answer would be, well, no, subject to obviously certain exceptions based on the nature of the society. But it's just worth noting that financial statements are something that are reviewed by the society, or by and it should be available to the members of the society at the annual general meeting.
Could I just add to that too, Johnathan? Just because of the Freedom of Information Act and things for members, this is something that your bylaws could outline then as to limit the amount of information you need to share if somebody requests.
Yeah, that's a good example. And what we sometimes see is bylaws dictating when and how the financial statements will be available. So whether or not it's something that, well, someone can come and attend a certain location to view them, but they won't actually be sent out to people, to prevent further, what's the word I'm looking for, circulation, I guess. So yeah, again, it comes back down to, it's why it's important to make sure that you can speak with a legal professional in properly setting out in your bylaws what you want, how you want your society to operate, and where you want its limits and parameters to be. Mm-hmm. Oh, and Christine brings up a very good point that I'll just reiterate if people don't have the chat up, is that it's unlikely that unincorporated nonprofits will receive public funding, i.e. grants from a municipality, for example. And that makes sense because, again, from a practical perspective, it looks like you're just giving a person, as well-intentioned as they might be, a sum of money. Incorporated not-profits, I mean, this isn't a legal answer right here, but incorporation also provides a certain perception of legitimacy, I think is probably the best way that I can put it, because the law does have certain requirements and prescriptions that a society needs to run by, or needs to be operated pursuant to. It basically carries with it that if a society has been properly, or if an organization, not for profit has been properly incorporated, well, it means it's going to be meeting these requirements, and with that comes a certain aspect of legitimacy and governance, and reliability as well. As again to Christine's point there, if a not-for-profit is receiving public funding, well, how that public funding came in, how it was being used, what's left over, et cetera. Well, that's all going to be disclosed in the financial statement. So again, having an incorporated entity that has these annual filing requirements and financial disclosure requirements gives a little bit of security for the people providing these grants that we're going to give it to this cause. We think they're going to do a good job with it, but we get to double check when those financial statements start getting produced, which obviously isn't a requirement if you're just giving it to mom and pop who are accepting donations, to use the quote in the earlier question.
Sorry, can I just, Ethan had put his hand up, and Ethan, I've given you the option, if you unmute yourself, you can ask your question live, if that works for you. Just while Ethan might be trying to struggle with the mute and unmute button, because I know sometimes I do that. I just wanted to reiterate, somebody had asked about the model bylaws, and there is a link in the chat. I add to Jonathan's caution, though, about it's always good to get some advice on the matter, because the model bylaws are only meant as a guideline for you, and each organization is going to have specific requirements, things that you want to address as far as board of director tenures, how to recruit, like how long people are in their positions, all of those things. It's going to be different for each organization. So the model bylaws are there as a guideline to start you off and get you thinking about those things. But I think we can all agree that the law is nuanced, and so getting some good advice is a good idea. So I'm not sure if Ethan had a question or not, but there are a couple of other ones that were posted up then, Jonathan. Generally, how much time does an attorney require to draft bylaws?
Ooh, I use a lawyer's favorite answer. It depends. It's going to differ depending on the nature of your society. I mean, I used an example earlier about MAD Canada. That's a large society. YMCA Okanagan. It's a large society. You know, these are just off the top of my head societies that I can only anticipate have more complex bylaws than one that might be created for, to use my other example, simply taking up underprivileged teens to Big White on the weekends with a rented bus. You know, different sizes of societies and organizations are going to require different different lengths and complexity of their bylaws based on their operations for society. So, short answer is I can't give that answer. It depends. It's going to be different. Can you be both a director and employee of an incorporated society? I wouldn't recommend that due to conflict of interest issues. Again, I'm just going to say that's kind of it depends based on the nature of the society. It's possible for a director to be a volunteer under the society still, but that's when I'm just going to back away and say it depends on the roles. Mike R, thanks, missed that. Oh, okay, there we go. I think that was.
Any other questions from anybody? This is the time to ask. We've got a great mind of Jonathan to help us out. I will be sharing it just to let everybody know. I'll be sharing the link to the recording for this one as well as the slides, so that you'll have that to refer to as well. And then we're also always here at KCR to help you and direct you to other resources and other and just have a discussion with you if that's what you would like to do, or to try and connect you with other people in the community that can help guide you in some of this. I think the nonprofit world is such an amazing world to be a part of. And one of the reasons is because there are always people there that want to help. You know, that's the whole thing about Mr. Rogers, look for the helpers. The nonprofit world is going to be filled with helpers. And the best thing is to try and find an organization that is similar to yours in some aspect, and then reach out to that organization and try and get some guidance from them, and or to look for bylaws that they might have already created to help guide you in some of the things that that you're looking to create. So don't be afraid to reach out to others in the nonprofit world, because most people are there to try and help and support, and they're more than willing to usually help. So any other questions from anybody? I feel like almost an auctioneer, going once, going twice.
well, what I'll say then in closing is that, you know, it's not unusual for about half an hour after a presentation for someone to be thinking about it, like, oh shoot, I wish I had asked this or that. So obviously you can see on the screen right now my contact information. Obviously, feel free for anybody to reach out if you have any questions. Be aware that I'll be limited to how much detail I can give in an answer, obviously, because there are certain professional obligations that restrict the extent to how much legal advice I can provide you. But do feel free to reach out to me. I'd love to help clear up any confusion that you guys have. And obviously, if you do have a society that you're looking for more specific professional help with, never hesitate to reach out to me or any of my colleagues at Doak Shirreff Lawyers.
A great firm. Good. If you're looking for that person, not just to be a director on your board, but to help guide you through the process, Johnathan is a great person for that. Thank you very much, Johnathan. It's been really wonderful to host these sessions with you and have your support while we're doing this. And I'd like to thank all of the participants along the year that it's been here. And I'm just so happy and thrilled when I hear from people that they've gain some confidence in the skills or in their knowledge and are better board directors or better volunteers for their organizations. That's why we're doing these webinars, and well, we're doing webinars now, honestly, because of COVID. We used to like to meet in person, and hopefully we will again, but I think this technology is also a really great way to be able to connect with people and then share the recording as well afterwards. So there are always silver linings to these things. Thank you to everyone for participating. I'm just going to give you one quick reminder again about Thursday. We're going to have a nonprofit town hall moderated with Norm Letnick, and we're going to be talking about seniors and organizations in their communities in Lake Country, in West Kelowna, in Peachland, and in Kelowna that are working with seniors and supporting and offering services for them. So please tune in. You can check us out on Facebook, or you can register with us, and I'll share that link out as well. And then you can join the webinar and ask questions and answers during that session as well. Thanks, everyone. And thank you again, Johnathan. Really great to have your support. Thanks very much.
Bye.
Take care, everyone.